Okay. Hi, this is Brian Panish, and we're being joined here today by John Taylor, a world-renowned trial lawyer based in Los Angeles. John attended the University of Ohio in Athens, Ohio, where he's a member of the intercollegiate hockey team. He then returned back to his native California, attended McGeorge Law School, and has been practicing law now, I believe, for over 40 years, and has obtained some of the landmark verdicts and settlements in the state of California throughout his career. So, John, thanks for being here. It's great to have you on the air today.
Thanks, Brian, for having me.
John, I want to get right to it, and I would like to ask you, for young lawyers listening to this that want to be a trial lawyer, I know you've tried over 200 jury trials. You've had a lot of experience in the courtroom. Things have changed today. How would you advise a young attorney that wants to be a trial lawyer to do it? What do they do? What are the options they have?
Well, I think a couple things is when you go to court for whatever purpose, whether it's on a law and motion matter, you're down in the courthouse, is to stick your head into a courtroom and it doesn't matter what the case is, it's to watch even cases, being tried, so that you're just getting exposed to trials and you sort of see how all the work you do during discovery or getting a case ready to go to trial, what it really means or what it looks like when you go to court. And after that, I think it's finding the opportunity and the people that will support you to give you the option to try a case. And then you got to go try cases, and you're going to win some and you're going to lose a lot.
Well, what about,
you got to get out there and do it.
I believe, if my recollection serves me right, that you worked at a period of time in your career as a public defender. Is that right?
I worked briefly in law school at the Sacramento Public Defender's Office, and at that time, as a law student, you could try cases as long as there was a lawyer in the courtroom with you. And I was very fortunate in law school to get a job first in a clinic with the Public Defender's Office, and then a summer job that lasted through my last year of law school. And during the time, I probably made close to 1,000. I mean, that seems impossible, but 1,000 speaking appearances in court as a law student where there was a lawyer in the court. Now, in doing that, that means everything from, arraignments to sentencing hearings, but also
preliminary hearings, things like
preliminary hearings. And in juvenile court, there were entire trials. I did at least a dozen fully contested juvenile court trials that would be tried to a judge or a referee alone.
So what I like to say is the more experience you get, the better. Some people disagree on this. I don't think it's a bad thing for someone to go to whether it be the district attorney, the public defender, the city attorney, to getting that in-court experience and still wanting to be a civil attorney. What are your thoughts about that?
I totally agree with you. I think that you've got to get comfortable on your feet talking in front of a judge and trying to persuade somebody, whether it's trying to persuade the judge or ultimately the jury, but you got to get some sort of experience. I think that there's a window of time that you've got to move on from being either in the DA's office or the public defender's office into civil law, because there's going to be some stuff that just does not translate. But I think having the ability to say that you spent X amount of time making appearances in court, that when it comes to the civil side of it, it should seem relatively simple in a lot of ways.
Yeah, I totally agree with you, and I think that experience is invaluable. And the way the practice is today, a lot of the young lawyers just don't have the opportunities, whether it's because the clients don't want them to be in court or the law firm can't take that chance. But really, I want to talk now about some areas of your practice, John, and I know you and your partner, David Ring, have been very involved in sexual abuse cases, primarily for minors, but not just for minors, involving schools and camps and government entities. What is it today about today's climate that seems to be bringing out in the news more and more of these cases?
I think that the victims are more courageous, and I know that sounds exaggerated or hyperbolic, but it's true. I think that the victims male or female, are brave enough to come forward. And likewise, I think that there's enough exposure, that potential that jurors have to both, just sex abuse and sexual assault cases, that they're more willing to listen, so that the subject matter itself doesn't turn somebody off so much that they just don't want to be involved in those cases. And also the idea that the victim, a lot of the stereotypical things, whether the victim might have been drinking, the victim might have been dressed provocatively, the victim, consented to the extent that they weren't forced, physically forced to do something sexually, that jurors get that now, and they're willing to entertain those claims in a big way.
Do you think somebody, and I've had this debate with others, let's say a female, it's a 17-year-old high school student, can they consent and have sexual relations with a teacher or an adult at that age?
No, and the age in consent in California is 18, and so the law is very protective in California about what can be used to argue the compliance of the minor with the adult perpetrator. And it's excluded, meaning that, and a lot of people have the misconception that the minor has to be physically forced in some fashion, or that if the minor complies, consents, claims they're in love with the perpetrator, pursues the relationship past the time of when they were a minor, that somehow that is all discoverable. And it's not. If you're a minor, the law says legally it's impossible for you to consent, and the defense cannot use consent as either a comparative fault factor in determining liability, nor can consent be brought in as a compromising issue in determining damages. The fact that the defendant might, many times we face the argument, the defense wants to argue, well, the minor, the kid was not physically forced to do that, and we ought to be able to argue that to the jury. And it does not matter. Consent, to the extent that it means that the minor is not physically forced, that consent cannot be used for either liability or damage purposes.
Okay, so what I've also noticed, and you don't read about every settlement, but you do see settlements with public entities, but I noticed that juries, at least on my observation, seem to be giving much larger verdicts in these type of cases. Would you agree with that? And if so, why do you think that's true? And one other point I'd like to talk about, is the percentage of fault. It used to be, at least my experience, that the perpetrator, the person that does the act, usually gets a much higher percentage than the school district or whoever's employer is. I again see that it seems to me that the perpetrator's percent of fault is going down, and the employer entity that supervises him or hired him, theirs is going up. So it seems that the verdicts are going up and the percentage on the perpetrators are going down, and the people that are employing them or supervising seem to be getting held more accountable. Could you talk about that?
I think the thing that we always say is that demographically, sexual assault and sexual abuse cases cut across all demographics. So it seems not to matter where the case is filed in terms of venue, whether it's considered a really conservative venue like Vista in North County, San Diego, to the more conservative districts here in courthouses here in Los Angeles County, that it doesn't seem to matter. Jurors get it, and jurors will compensate the plaintiffs on righteous cases. You're still going to have lower numbers in the more conservative jurisdictions, but ordinarily this type of case, no matter what the makeup of the jury is, they're much more receptive to it, because when you do the jury selection process, the number of people who have, sexual incidents that they're going to talk about, it's impossible really to get everybody off of the juror. Everybody's initial A lot of times initial exposure to something sexual is some family member that's been inappropriate, some other kid down the block, so that this type of landscape is not completely foreign to somebody. It's just now finally, people being comfortable to talk about it. I think overall now that people appreciate, and that's probably beginning with the clergy abuse cases, and then through the continuing ongoing sexual assault cases that we're aware of now, that the compensation numbers are larger. And I think it's that people appreciate the extent of how somebody's damaged. It used to be that when we had just minor kids who had been abused, you'd project, here's what is going to happen to them as they go through their relationships and as they go through their life. You need to have a therapist talk about that. And then as we've represented adult survivors of, childhood abuse, the things that the therapist said were going to happen to the kid did in fact happen to the adult. So there's all sorts of trust, relationship issues, a lot of times drug and alcohol abuse and misuse. And so those things proved to be true. So I think that maybe the experts' vocabulary for expressing those damages are better, and I think the jury's ability maybe to understand them and accept them is better, so that they are more willing to adequately compensate somebody and fully compensate somebody, as opposed to throwing some nominal amount at the case.
Do you think?
I also think on the percentage of fault between the perpetrator and whomever it might be the employer. So whether it's the school, the after-school program, the Boy Scouts, the soccer program, the volleyball summer program, whatever it might be, where the adult perpetrator is put in contact with the minor, that especially with the schools, that the juries get the idea that the school, the organization, is supposed to safeguard the minor. And so if the school fails to do its job and ignores the red flags that are invariably there with most of the perpetrators, that the jury gets the idea that if the school brings the dog or allows somebody to bring the dog that bites into the school and watches the dog do something that's hostile and then does nothing to get the dog back out of the school, that when the dog now bites somebody, the school is going to bear maybe a more than 50% share of the responsibility for not having prevented the interaction with the perpetrator to start with.
Do you think that the whole ordeal with the Catholic Church and things coming to light has put more of a shadow on or a spotlight on these cases and made jurors more believing that these things are going on?
Yeah, completely, totally. I think that probably the initial clergy abuse cases on that it took it to maybe be on that magnitude that somebody reading about it in the paper wouldn't either minimize the extent of the problem or the issue or the problems that a victim would have. I think that not only did you learn more from the news coverage of it, you learned more than from movies that were made that involved either that issue or other issues of child abuse, so that people are just more. I think as we keep saying, I mean, jurors get it. They're versatile and versed in the language and the vocabulary of the abuse, and they understand a lot of the nuances of the abuse. And in more difficult cases, not just the classic, older man, teenage, younger girl, but older men with teenage boys, so that there's much more sort of nuanced appreciation by the jurors of the damage that happens in those situations.
What about this, the Me Too movement? I mean, how does that, in your opinion, affect these sexual abuse cases?
I think the same thing. It's the exposure and the people seeing on the news that men in power, for the most part, men as opposed to women, but that men who hold some sort of power advantage over a female, either in the workplace, mostly in the workplace, that it's how it can be abused, and things that were sort of accepted as, well, it's okay if my boss makes comments to me about what I'm wearing as a younger female employee, or that my boss puts his hands on my shoulder when he comes by my office. That things that were sort of accepted in the past as being, well, that's just normal work environment type of activity. I think that people now again are more aware of that. It's more nuanced, that it doesn't have to be just flat out somebody grabbing you, that there's a lot of different ways in which men can either exploit or abuse people in a sexual fashion. So I think that, again, it makes it more comfortable for the victim to talk out and get, and there isn't quite the stigma of that. And so I think that it's better in that way.
We're spending a lot of time on this topic, but it's really important in today's society. So I want to ask you a few more questions on that. When you're trying, and I know you try a lot of these cases, are you allowed to, or does it commonly occur where you're doing individual voir dire with jurors in private, kind of like would occur maybe in a death penalty trial?
I think it depending on the judge, but yeah, I mean, the answer is yes. And we use questionnaires in all the cases. The judges have always allowed that. And if the surprising thing are the number of people who are quite candid and willing to talk about, like, really kind of horrific sexual things that have happened to them as kids in the presence of other people, which again tells me that either the stigma, embarrassment, whatever of the assault has changed from over the years. But I would say that almost all those cases, we spend the jury selection period takes several days, and most of that is probably doing individual jurors at a time. Anybody on the questionnaire who has indicated that they've been a victim, or a family member or close friend has been molested, or a victim of some sort of sexual assault, we do those people one at a time.
Well, and I think, judges commonly in California prior to the new law were very hesitant to give questionnaires because they thought they made the jury selection last longer. And they always say there's nothing special about this case, but I guess in a sexual abuse case, and due to the private nature, the judges appear to be, based on your experience, more willing to give written juror questionnaires.
Well, and especially ones that are tailored that have a whole series of questions that would be unique to the issues of the type of abuse, the location, both everything from the physical location, the relationship of the perpetrator and the victim. And so in the cases, I always think that the jury selection period is going to take a pretty long period of time, but the actual full questioning of the panel can be as little as a couple hours, because 80% of the people, 50% of the crowd that you're questioning to start off with, you probably will have talked to them individually before you even get them back into the general voir dire group to question everybody about the general things. But yeah, judges are willing and are sympathetic. I've not met a judge yet who's been overly constricted on time in questioning the jurors.
Have you ever come across a judge that has a reputation of limiting voir dire in a sexual abuse case, and they've kind of laxed or let up the reins on the voir dire in the sexual abuse case?
I was very surprised at trying a case a couple of years ago where the judge was, pretty experienced, both by my own prior experience years ago and trying a case in front of him, and then just by reputation. And the judge was more willing to, allow the question to go forward on the sex stuff.
But if it was
it makes sense.
Regular case, though, that judge would be more restrictive. But it was your experience in that kind of sexual abuse case, they kind of lightened up a little bit.
Completely, and give you more time. And it's really, when you see the people talk, I mean, there's a lot of people. You'll lose, as we say, we'll lose a lot of people right off the questionnaire. And as you know, and anybody who tries a lot of cases and uses questionnaires, you're going to lose people right off the questionnaire, or they'll say something, and a lot of time it's not the potential juror manipulating the questionnaire to get off of the trial. But what we'll find, I mean, that people who they will just flat out state, I cannot be a juror in this type of a case. I can't. And most of the time it's because they're a victim or they know a victim.
Well, yep. All right. So what are some of the common themes that are used in the trial of cases such as sexual abuse, where there's either, as you said, the YMCA, the after school program, the school, the Girl Scouts? What are the themes that seem to resonate with jurors that have come back with substantial verdicts in these cases?
I think that it's all the things that you would expect. I mean, these are places that, especially the schools, that the kids and the families, you really don't have a choice to whether you're going to go or not. And that's why the law extends, various exposures and looks, puts some immunities aside, because the attendance of the school is mandatory. And so once your child is in at the school for the 8 hours that the kid is going to be there, the school stands in the shoes of the parents. And so the safety of the kid and the supervision of the child is always, the big thing that all of us, and it's something that resonates and with all adults get it, whether they have kids or not, is that once you drop your kid off at the program, once you drop your kid off at school, that no matter what else goes on, we always start with, if you'd agree, the primary thing that happens is that the child goes home okay. It doesn't, there should be education, there should be sports camp, there should be a great time going hiking with the scouts, but at the end of the day, the program, whatever, the kid should come home, in good shape,
unscathed,
and not having been touched by somebody, so unscarred, right? Of course.
So when you're arguing
those things,
Okay, so let's take it to the final argument. You're arguing a case that, generally speaking, in this kind of case, let me ask you this first. Most of the medical expenses for the therapist as such is not going to be a lot. Are you going to put on that evidence? Let's say it's $20,000. Are you going to put that on as evidence in your case? Or are you going to waive that? How are you going to handle that?
It depends. I think a lot of times you put it on because I think the jury is going to expect, okay, the kid or the person's now been in therapy for a period of time. That usually the therapist, you're going to put on an expert who talks about the future care the person needs, and it's going to be a lifelong, therapy program. And those numbers are going to be relatively modest when compared to the care of somebody who's got constant ongoing future care costs. So, there'll be several $100,000 only, and we absolutely put those in. But the general damages arguments are it's a look at what the person had and what was taken from them. And really, especially with kids where, they've taken innocence, they've taken their naivete, they're taken, sadly, their ability to trust, and not just trust, it's trust, not just men, it's trust in any type of relationship, whether it's somebody they work for, somebody who they're going to become friends with, and it's not something that's going to end with, some brief period of therapy. It's something that, and it's for, kids where they are sexually naive or inexperienced or lack any sophisticated experience, to have some of their first sexual experience be, very extreme molestation or sexual acts. It's horrific, and the damage is horrific.
Well, listen, John, thanks for all the great work you and your firm do in helping the victims and getting this out in the public and hopefully making it better. I know you guys are doing a big push to make things better for everyone. I wanted to talk to you about your experience in police misconduct cases. So I'd ask if you could come back another time, and we'll do that again. And I really appreciate you taking time out of your busy schedule to spend the time here with our listeners. Thank you very
Would
much.
love to do it again. Thanks,
I'm
Brian.
looking forward to it. Take care. Bye-bye.
You too. Bye-bye.